Thank you and good afternoon. There are three great fears that I have in being a panelist this afternoon. The first I've resolved by wearing my reading glasses. The second great fear that I have is being the last to speak. I am keenly aware that I've got about 3 minutes to capture your attention before you start thinking about the break or the restrooms and so forth. So I'll endeavor to really try to capture your attention with some sharp focus on the question that I'm going to be talking about. The last fear that I have is that I'll turn on inadvertently. Fears are coming true, Jeff. I'm going to have to revise that to 4 great fears. And the last great fear is that you will be preempted in your remarks. And I have to say that I wanted to pick a topic that no one else was going to focus on. And I started researching the Massachusetts versus EPA case and all of the legal issues that were nice with regards to that. And I thought, well, somebody's going to inevitably talk about that issue, so I need to pick something that no one will talk about. And I discovered yesterday at the American Bar Association annual water law meeting, which is held in San Diego each year, that one of the focuses of the conference was on the topic that I was going to speak on. So if any of you went to the water law conference yesterday, you've been exposed to some of the ideas. Now, if that's not bad enough to be preempted, we have one of the preeminent scholars who argued the case before the United States Supreme Court in early December here, and he gave a class this morning on my same topic. So I greatly resent being preempted by Richie Lazarus and Christy Bullitt, who's a Washington attorney. One of the starting points that I'd like to talk about is why this is going to cost you more. That ought to interest you. Why this is bad for the environment. That ought to interest you. And the centerpiece of my conversation this afternoon is on the Federal Clean Water Act. And one of the things that's quite notable about the Federal Clean Water Act is the number of cases the United States Supreme Court has taken up in the last 10 years or so. In 2001, they decided the Friends of the Earth versus Laidlaw case, which was a citizen suit case, which has broad implications with regards to citizens suing either the U.S. EPA or state government to do their job. In 2001, there was the Solid Waste Agency of Northern Cook County versus Army Corps of Engineers case, which dealt with isolated wetlands and federal jurisdiction over that. 2002, there was the Borden Ranch case. Interestingly, the principal plaintiff in that case was the father of a former student of mine, so that was a very exciting thing to follow as it progressed. In 2004, the South Florida Water Municipal District had a kerfuffle with the Miccosukee tribe in Florida. In 2006, there was the Carabel versus Army Corps of Engineers case and the U.S. Versus Rapanos case, as well as the S.D. Warren versus Board of Environmental Protection case, which was a dam case dealing with discharges. This year, there are really 2 cases, one of which I'm going to talk about, and that's the Entergy versus U.S. EPA case, which has been retitled Entergy versus Riverkeeper for various reasons. Now, at the dinner last night for the panelists, I was talking to Richie Lazarus about my paper not speculating on the outcome of the case, leaving the issue somewhat adrift. And I don't know whether he remembers this, but I do. He said, well, it's fun to speculate. So I'm going to speculate. It will be a 6-3 decision, reversing the environmentalist claims and sustaining the US EPA's Phase 2 regulations with implications to the Phase 1 regulations as well as the Phase 3 regulations. Now, that doesn't make any sense to you at this point, but I'll get to that in a little bit. I quite agree with the assessment that this particular case, which deals with cooling water intake structures, which is a subject that if you're interested in water issues, you can spend your whole life and not come up to or against the cooling water intake structure provisions of the Clean Water Act. When I was chair of the water board in this region, I had 3 cases that dealt with cooling water intake structures. All of them were quite instructive to me and really quite removed from what's going on before the United States Supreme Court today. And cutting to the chase of the issue, cooling water intake structures come in one of 2 forms. One form is what I'll call the leaky radiator case. And this is a once-through cooling system, so that if you have a leaky radiator, you have to continually fill it up. The other is the solid radiator case, where the cooling system operates on a regular basis and relatively rarely do you have to fill it up. And then there's the VW Bug air-cooled system, where you don't have to use water at all. And these are the 3 competing technologies that are present with respect to cooling water intake structures. I think it's 42.6, and Richie can correct me if I'm wrong on this, 42.6% of the existing power plants in the United States use once-through cooling, so they contribute a significant amount of energy to our system. There is an environmental movement that is in place at the federal level and certainly also at the state level. The State Lands Commission, for example, has some resolutions. They want to move society away from once-through cooling. And why do they want to move society away from once-through cooling? Well, the answer is there are at least 2 serious environmental concerns that need to be placed on the table. The first is with regards to the intake structure. These power plants, these 540 power plants, withdraw trillions of gallons of water a year into the system. As a result, there is significant impingement on the screens that are set up to block logs and other detritus and fish and so forth from entering the system. Those small organisms, merameciums and fish eggs and so forth get through the initial screening, have a tendency to get entrained in the system, and the journey through a power plant cooling system is not a happy one for the paramecium. They tend to suffer a high mortality rate, although there is some factual disagreement on exactly what that mortality rate is. It's primarily a function, as you would probably guess, as to the number of marine organisms in the source cooling water, the velocity of the intake of the power plant, and the pressures to which they're subjected. Of course, there are various algicides and other things added to the cooling system that add to the unpleasantness of the paramecium's journey through the cooling system. So that's one of the big issues. We are killing, entraining, and destroying vast quantities of marine life.